A judge heard arguments today from lawyers representing the governor and the Republican legislature trying to strike down her stay-home orders.
Our Michael Martin was listening in on that hearing this morning. He tells us where the case stands now. Michael.
Yeah, guys, good afternoon. That Michigan Court of Claims judge hasn't made a decision either way at this point. Today's hearings, or these oral arguments, being made over Zoom. So kind of a unique situation born out of this coronavirus pandemic. But it should be some time, at least into next week, before we hear a decision from that judge as to whether the governor's orders will be struck down.
Despite their protestations that essentially the governor has stolen power from the legislature, they remain perfectly able to pass laws, hold hearings, introduce bills, do all the things that a legislature does.
On Friday, Judge Cynthia Diane Stevens of Michigan's Court of Claims heard arguments in a lawsuit brought by the state House and Senate against Governor Gretchen Whitmer. They claim the executive orders the governor made in response to the current pandemic go against state law.
This is not just about whether we agree with the manner in which a law has been executed. This is about her depriving us of the legislative tools that we would otherwise possess to help manage this pandemic.
The governor issued her recent executive orders under two Michigan laws: the Emergency Powers of the Government Act, signed into state law in 1945, and the Emergency Management Act of 1976.
This is not an argument about the existence or non-existence of a crisis. This case is instead about a question of whether a governor, this governor, or any governor in the future can exercise effectively a limitless, unilateral, temporally unbounded authority, exercising the lawmaking power of this state for as long as the governor wishes.
They argue that the 1976 Act requires the governor to consult with the legislature prior to extending a state of emergency beyond 28 days.
Both of those authorizations contained particularized limits on the execution of the powers given within them.
Attorney Chris Allen, representing the governor, says that is not the case when the emergency itself extends beyond that time period and requires additional immediate action.
There's nothing in the text at all about the governor's inability to continue responding if the disaster exists.
The lawsuit also argues that the 1945 Act only applies to local emergencies, not situations that extend throughout the state.
If a governor is really going to assert that degree of broad power, that degree of just generalized, all-encompassing power, there needs to be some mechanism by which the people's legislators can say, no, we're ready to take the reins. We're ready to be the ones to actually reassume the lawmaking power.
The suit asking the judge to declare the governor's state of emergency invalid.
Your Honor, we would just ask that Your Honor declare the declarations of state of emergency and disaster invalid and improper and its ultra various acts unsustained by the Constitution or statute.
But Allen says that the governor has acted correctly under the law.
The legislature has the means to make the very changes they want to these laws in their own chamber. But the legislatures of years past, they wisely recognized and properly delegated that emergency authority to the governor.
Yeah, so again, that judge making no decision today, expected at some point next week at the earliest. For now, live in downtown Grand Rapids, Michael Martin, Fox 17 News.
All right, thank you, Michael.